Hey, the YouTube fans, Mike Palumbo, and I want to bring to you. I want to do a case study of a trial I just did, where my client was charged with failing to yield to a bicyclist in New York City, and he struck the bicyclist, or actually, the bicyclist actually struck him. That's really what happened. But he was charged, and the bicyclist was injured. The bicyclist was injured. So that makes it a crime to fail to yield to a pedestrian or bicyclist, and there's an injury. And it's an interesting case because the case went off in what we call the Oath Court in New York City, Office of Administrative Trials and Hearings, and it's a specialized court that generally hears trials from employees, administrative trials of employees of the city of New York. They also hear city code violations. So he was charged under the city code for failing to yield to pedestrian. Could have charged him under state law, but didn't. Charged him under city code, so it went to this particular court. And even though it's not in a judicial court like the criminal court, it's still a crime. It was still a misdemeanor. Cities can make crimes under their code, believe it or not. So it's still a very serious matter. Now, the first thing is, it's whenever you have a lawyer and a lawyer does a trial, it's not sufficient just to have a really good, you want to get obviously a good trial. What makes a good trial lawyer? The lawyer has to understand and know the venue that he's in and the rules and regulations of that venue, which I leverage to my client's advantage in this case. You also have to understand, while this is a criminal trial, I'm in an oath court. It's an administrative tribunal. I'm still in. The burden of proof is different. It's actually less. It's by clear and convincing evidence. It's not by beyond a reasonable doubt. That's important for your lawyer to know. That's easier to get your client convicted. Now, the way this venue works is that my client gets a ticket. He was ticketed at the scene. He wasn't taken into custody. But he's still charged with a crime. Whether or not you're taken into custody is not really material. And he gets the ticket. On the back of the ticket, which I don't see. Actually, I did pull it. I'm sorry. I did before the trial. I got it. Back of the ticket has a narrative on it. A mini report that the cop writes. Now that narrative, legally significant. That narrative has to state a prima facie case, court to have jurisdiction, and if it doesn't, you move to dismiss. It just basically said that my client's vehicle struck the bicyclist in a bicycle lane. That's all it said. Okay, it's actually not even what happened. That is not enough. Even though he claimed it was in a bicycle lane, to state a prima facie case under the statute. So what happened was I ended up, I pulled the police accident report just to see what was on the police accident report as well, because that's going to give me an indication of what the cop's going to testify to, and the accident happened at an intersection that was controlled by a traffic light. It doesn't say my client ran a light. It just said he was making a left. And he struck the bicyclist as he was making a left, which is kind of inconsistent. It doesn't say anything about a bicycle lane. In fact, there is no bicycle lane in that area. In that area of the city, it was in Queens. There is no bicycle lane. He was turning left. My client was turning left onto a one-way street, which was going north. So he's turning northbound left, the correct way onto a one-way street with the light. And on both sides of the street, it was almost like a side street. It was like a service road to a main street. There was a little park there, and on both sides of the street is parking, vehicular parking that cars can park on. It's a one-lane road, and on both sides of the street is parking. And I had the photographs and everything, but when I started the trial, now the trial was done over the phone because of COVID. I wanted to upload these photographs, and the judge said, "No, don't." I drive by there every day to go to work. I know the intersection, so you don't got to put the photos in. I know. I'm taking notice that there's no bicycle lane. I know there's a park, and she's like, I drive down that road almost every day. So I was like, okay, she knows what it looks like. So she said to me on the phone, well, the cop isn't here, and even if he is here, you have a right to cross-examine him in person. Now, counselor, do you want to waive that right? And I have my client on the phone on a conference call. Do you want to waive that right, or do you want to a subpoena the police officer, and then you're going to come in person. Now, there was no prima facie case made. The police accident report was didn't really say much. Nonetheless, I don't want to give the cop a chance. Now this can go either way, right? It's like you want to cross-examine the main witness. If I don't have a witness there to cross-examine, then I can't really contest the paperwork that he submitted, right? But in this case, my argument was there's no prima facie case. You got to dismiss this right now. So if I say no, I want the witness there, he could then potentially cure through his direct testimony. Still should be dismissed because there's no prima facie case. We should never reach his direct testimony. But yet it's still there, so I got a greater propensity of having my client plead guilty. So, less is more in this case. So I said, no, we're going to waive it. Now, that's a tactical decision. That's a decision that, that a lawyer is going to make. And you really can't, it's not fair to second guess a lawyer because you're there, you're standing up. I prepped the case, I prepped my client, I've discussed the facts and circumstances with my client, and I knew he was going to testify well. He was going straight, intended on making a left. It's controlled by a traffic light. He had the green light. Traffic was coming the opposite direction. He waited for it to clear, and he made his left. And he was almost out of his left where the bicyclist then hit him in the front right of his car. So the way the accident happened was consistent with the fact that my client didn't hit the guy, didn't run over the guy. The guy ran into my client's car, and he was coming through that intersection, so he ran the red light. And again, the police, nothing indicates who ran the red light. Like, nothing indicates who had the right of way. So I knew how my guy was going to testify. So you know what? I made that decision. I said no. And I said, Judge, before we begin, I gave a recitation of the law. I gave a recitation, very briefly because I know she knows the rules of her court. And I said, I move to dismiss. There's nothing here. And she said, well, I'll take that under advisement. Do you want to call your witness? So now it's like, now if I had a bad witness, I probably would have said no. I would have said no. Or if I had unfavorable facts, I would have said no. I don't. But he was a sharp guy. He was in his mid-50s. He's taking his granddaughter to her dance class. She's in a car seat. He was using his son's car because his son's car has a car seat. Like every Tuesday, he takes his daughter to her dance class. His wife was like I want to say a doctor or a dentist or something, and he ran the wife's office. He was the office manager. He worked for his wife. He was a family man, And so, I went through this thing, like, do you work? Some little background about that. Hey, do you work? Yeah. Well, it was a Tuesday. Well, I work. I work for my wife. I take off every Tuesday. Oh, she does take off. Ha ha ha. Right. A little. And basically, I'm saying, well, was it your car? I was like, no, it was my son's. Well, you familiar with it? Why are you driving your son's car? Well, my son's car has a car seat in it. Oh, and for my granddaughter, I take her to dance every Saturday. Now, every Tuesday. That's why I take off every Tuesday to spend time with my granddaughter. And he's using a car where there's a car seat in it. So without me having to say, hey, this guy was driving safe, he's a regular guy, I'm proving his regular guyness through a little bit of background, a little bit of who you are, and every question I ask is purposeful because I don't want to say, well, you were taking your granddaughter to her dance. Was she secure in a car seat pursuant to New York law? Yes, she was. I was like, oh no, well, I was using my son's car. How come you weren't using your car? Oh, I don't have the car seat in it. Oh, you were taking all right, you were taking your granddaughter. So you wanted to make sure she was in a car seat. So you wanted to that's why you took your son's car that day. So you drove to your son's house and then you switched cars, and that's what you do every Tuesday. Well, that proves he's familiar with the car, and I don't have to ask him directly. Well, what was your granddaughter in her car seat? Because that shows he's going to drive. That's proving he's a careful driver. He's not reckless. He's got his granddaughter with him. He works for his wife. He's a family man. He's a guy. He's a family guy. He's taking care of his granddaughter. He's a regular guy. He's not the kind of guy to go running a red light. So I walked him through all that. his testimony, and he said, look, I made the left, and all of a sudden I heard a noise, and whatnot, and I was almost done with my turn. I was in the lane. I don't know where the guy came out of, but he hit me. That was his testimony. So the judge said, okay, I'll take it under advisement, and I got a decision back, and the decision said, at the outset, Mr. Palumbo moved to dismiss for the summons failing to state a prima facie case. He argued that the issuing officer failed to allege the respondent did not yield to the cyclist or that the accident was caused by any action or inaction by the respondent. And then she recites his testimony, what he testified to. And then she says, remember I said, okay, you made your motion to dismiss, I'll take it under advisement, but do you want to call any witnesses just in case? I got to make a decision on the facts. And then he testified, but then she says, motion to dismiss is granted. So in other words, even though my client testified, it was irrelevant because, she would have had to deny my motion and then say, well, I heard his testimony and I find him believable, I find him credible, and I find that he didn't cause this action. So what she made was, she didn't make a finding of fact, she made a finding of law. So she said, I agree with Mr. Palumbo on the law, that I don't have jurisdiction. So I find that the summons, which alleges that the respondent struck the cyclist, I find a summons which alleges the respondent struck the cyclist, but does not state the driver failed to yield or that the cyclist had the right of way. Fails to allege the essential elements of the section of the law cited. Therefore, I find that the summons fails to establish a prima facie case and is unnecessary to address the merits of respondent's defense. Summons is dismissed. So I won on really the best way you could ever win without even having to put on a case. When I put the case on, because she's like, okay, do you want to waive forevermore your right to your client to testify? And I would have done that if he was a horrible witness or the facts were unfavorable. I'm like, yeah, he's not going to testify. But I prepped him. He was very consistent in what he said. It was consistent with the way the intersection was. It was the police accident report really didn't refute anything, and I was glad to not have the cop there. But this case just showed. This is a misdemeanor. This would have went on his criminal record. He wasn't going to go to jail, but he's going to have a crime. He was going to be convicted of a crime. It was going to impact his insurance rates greatly. Anytime he went he worked for his wife, I'm sure his wife wouldn't have fired him, but it could have impacted him down the road. Getting a job. It was an important case for him. So the thing is, when you hire a lawyer, you want the lawyer. You can have the greatest lawyer in the world. If I got to step into federal court on a misdemeanor, I'm not the right lawyer for that. I've never done a federal case. I can do a very minor federal case in federal court, and probably wouldn't be the right lawyer for it. Certainly would be the right lawyer for it if I was second chairing someone and understood and learned criminal procedure, and I would be the right lawyer for it down the road. But I wouldn't, you want to find a lawyer. So I understand this court. I understand an administrative proceeding versus a judicial proceeding. I know the rules. I'm in this court a lot. I know the rules and regulations of the court. I know what the case law is, surrounding appeals that come out of this court. So I was definitely the right lawyer for this case. And that is the overarching thing. Always find a lawyer that's right for your case. And it's not always just the lawyer has 20 gazillion years of experience. It has to have experience in what you need at that time. All right, took up enough of your time. It's Mike Palumbo again. Thanks for listening. And I'll catch you on the next one.